An appeal in the matter of Tzvi Soriano and Forensic News LLC and others.
My ladies, my lord, I appear for the first to fifth defendants in this in the underlying action, as I did below before Mr. Justice Jay. Those defendants are now the appellants in the first appeal you will hear, which is the appeal in relation to Section 9 of the Defamation Act 2013, and the claimant is the respondent to that appeal. My learned friend, Mr. Greg Callis, appears for the claimant, as he did below. The claimant is the appellant in the second appeal that you will hear, and to that appeal, my clients are the defendants, the respondents, I should say. For the sake of what I hope is clarity, I propose to refer to the parties by their capacities in the underlying action. That is to say, the claimant and the defendants.
That sounds a very good plan.
In relation to the defendants, whilst there were 6 defendants to the action originally, the action brought against the former 6th defendant, Mr. Richard Silverstein, has been settled, so we understand. The appeals that related to him have also therefore now fallen away. When I refer to the defendants, therefore, I do so to the exclusion of Mr. Silverstein. It may, however, be relevant and necessary to refer to some aspects of the case against him as it developed and was, in fact, decided by Mr. Justice Johnson. Before I deal with the order of play, which I'll come on to shortly, may I take up one other pretty minor matter of housekeeping. Those of us intending to refer to the electronic bundles of authorities that may already have discovered that the council certificates, which are supposed to be in the front of the paper authority bundles, have been included in the electronic bundles, displacing the page numbering by a digit, for which we apologise. There is a way of dealing with that for anyone with the capacity to delete a page from a PDF, and that is to delete that page. The other method I would recommend, if that's not possible, is the subtraction method. But it's only a single digit, and I don't think it's going to cause too many problems. I apologise again. Now, a timetable of sorts was agreed between Council yesterday and transmitted helpfully by Mr. Callis to the President, to the President's clerk, and to refresh the bench, and also perhaps for the benefit of anyone following these proceedings. I'll just recap that timetable so we know where we are and where we're going. The time estimate was cut from 2 to 1.5 days following compromise of the appeal relating to the 6th defendant. So we have until lunchtime tomorrow. The defendants' 2 grounds of appeal will take up today. And by that I mean points that I will make in support of those, and the points that Mr. Kaz will make that are relevant to them in his respondent's notice. The time will be used as follows. From now until around 12:30, I'll open the appeal. Mr. Kaz will respond between 12:30 and 1, and then again from 2 to about 4. And I will reply by close of play today, so that disposes of my appeal, hopefully. With tomorrow morning given over to Mr. Callis's cross appeal on the malicious falsehood and data protection points, which are no small matters themselves, but we have agreed that we can dispose of them by lunchtime tomorrow. Mr. Callis will spend an hour opening that cross appeal between 10:30 and 11:30. I will respond for an hour, and he will reply for half an hour, and that takes up to 1 o'clock tomorrow. No breaks other than lunch are scheduled in that timetable, but we will happily accommodate any breaks if necessary. I should say there's been an agreed chronology, which has been added to the end of the core bundle at new tab 21, deals mostly with procedural matters, but whilst I won't be referring to it, it is a possibly useful document in what is a relatively procedurally complex case, and I'll refer at the bench to it. Unless there are other preliminary matters to deal with, I will turn to the defendants' appeal. So, turning, if I may, to my stance appeal, there are two grounds of appeal appear in the core bundle, in the notice at page A14 behind tab 1. No need to turn them up now. They appeal against paragraph 1 of the order of the 15th of January, by which Mr. J permitted the claimant to serve them in their various jurisdictions in the USA in relation to the libel action, and also in relation to a misuse of private information claim in relation to 4 photographs. The court may recall that there had been a sweeping claim in misuse of private information, a claim that anything published by the defendants identifying the claimant amounted to a misuse of his private information. That didn't survive the application to serve out, having been rejected by Mr. Justice J on simply pleading grounds. It was not sufficiently particular. He did, however, permit a misuse of private information claim in relation to 4 photographs to proceed, but he did so only parasitically upon the libel action proceeding. And in the vernacular, if that goes, the private information claim goes with it. And I don't therefore propose, we haven't appealed in relation to this private information claim that was allowed to proceed. I don't propose to return to it, simply to say that if you're with me on the disposal of my appeal, having found for me on the appeal, then we say that must follow the libel claim out of the window. The nub of the defendant's case on its appeal, as it was in fact below, is as follows, and I'll just introduce it in the round before heading into the detail. So as at the date of JJ's decision, indeed as at the date of the application, these 4 American individuals, 2 from California, 1 from New York and 1 from Pennsylvania, and a Californian corporate entity, were not subject to the jurisdiction of the English court. None of them has any connection to the jurisdiction. There was no protocol-compliant pre-action procedure followed. They were, in a real sense, strangers to this court and its procedures, strangers to its jurisdiction. And this was a product of the step taken by Mr. Justice Nicklin, of which we don't complain. But it is to be borne in mind that it was unprecedented. I won't say unorthodox. There's a lot of sense in what he did. So what he did was this: noting that an application, a substantial application, to serve in the United States was due to be heard without notice, anticipating that if permission was granted, it might give rise to an application to their side. Mr. Justice Nicklin effectively removed a step in the procedure, the without notice step, and required that the papers be sent, I won't say served, but be sent, so that some kind of notice was given of these steps to those that are now the defendants. This device, as practical as it was, becomes quite significant further down the line when we're looking at case law which deals with challenges to jurisdiction following an order that the court has jurisdiction over particular defendants. The court will be aware that in the normal course of private law applications to serve out of the jurisdiction, the first step is a without notice application, upon which an order is made. Now, that order may be challenged, frequently is, for various reasons, including procedurally for material non-disclosure or substantively for failure to on the basis that there's been a failure to establish proper personal jurisdiction. And any time it is challenged, we'll come on to this, those challenging, under the old maxim that he who asserts must prove, do bear some kind of burden. The unusual circumstances of this case gave rise to a hearing involving individuals over whom no jurisdiction had been claimed by the court, accepted by the court. And we say that materially changes the application of the maxim. We say they were not in fact required to assert anything in those circumstances. Now, I hope it can be said that in large measure their engagement was of assistance to the court. And in fact, they served by far the greatest amount of factual evidence about their own circumstances, and in fact, by far the greatest amount of evidence in relation to the claimant himself. And again, I will come on to that. But they did so, de bene esse, in our case. They did so because they were invited to attend a hearing, not because they were challenging jurisdiction that had been assumed, granted by the court. All of the burdens were on the claimant in those circumstances. I'll mention one more peculiarity that this has given rise to. I'll take your ladyship and your lordship to the passage at some stage a little bit later, but you'll recall, because it's a very salient point in our appellant's notice and grounds of appeal, that Mr. Justice J held that the claimant had been less than forthcoming in relation to his assets and reputation globally. And that language, had it been used in an application to set aside an order made without notice, would have set alarm bells ringing. It would have almost certainly been the door through which was driven a submission that the claimant had failed to give full and frank disclosure. I mean, it's exactly the opposite of full and frank disclosure, a failure to be frank about one's global reputation and business interests. And the fact that that did not happen, again, is an accident of the course taken by Mr. Justice Nicton, because had he permitted the without notice application to proceed, and the same finding had been made by Mr. Justice J or any other judge or master in relation to how forthcoming the claimant would be, one can see that that would have been a significant prop in the defendant's arguments to set aside. And in fact, without it taking on the moniker of a full and frank argument, it was a significant prop in their arguments on the application to serve out, because they pointed to the fact that there had been this failure to respond properly to questions about global interest, there's been this reticence, this silence, and we say that should have been dispositive. So the claimant was seeking to persuade the court below to exercise its jurisdiction over these strangers, these Americans, in a defamation action. Now, there was and is a clear statutory framework now in Section 9 of the Defamation Act 2013. And there is a roadmap from the subsequent case law by which the claimant in such circumstances is required to satisfy the court of certain matters, which we'll look at in a little more detail. If the court is not satisfied with those matters, the claim should be rejected. It's a simple equation. Has the claimant satisfied the court? And if the claimant has not, that's the end of the matter. So at this stage, I'm asking us to cast our minds back to perhaps the eve of the hearing before Mr. Justice J, or the hearing itself, where no personal jurisdiction had been established over the defendants, Their involvement in the proceedings to that point had always been without prejudice to that point. There had been no jurisdiction established, whether without notice or at all. The defendant should not have been under a burdensome requirement imposed by the English court to obtain and present expert evidence of foreign law in the multiple jurisdictions from which they hailed. Such evidence would have been expensive, cumbersome, and should not have been expected of strangers to them. So, it was for the claimant to make the running. That, I have...
No doubt you're coming to this, but if the position had been the conventional one, as you would describe it, where there had been an application ex parte, what would the position have been with regard to the defendants in what Mr. Justice Nicklin would have regarded as the inevitable application to set aside?
I take that in stages. First of all, Mr. Justice Nicklin's prediction about the inevitable application somewhat rides on the assumption that the application would have succeeded in one way or another. But let's assume that it has succeeded.
We're talking. I mean, you've started by dealing with hypotheticals.
Yes. Assuming it had succeeded, the defendants would have had they would have been subject to the jurisdiction of the court by virtue of the order obtained without notice. The first thing to say about that, again, flesh will be added to this further into my submissions, but the case law, in fact, it's picked up by my learned friend and was picked up below, in such circumstances, has established the legal burden remains on the claimant as a set-aside application to establish the jurisdiction claim. But there is, at that stage, an evidential burden arising out of this maxim that he who asserts must prove. In other words, jurisdiction has been assumed has been ordered by the English court over the defendants. The defendants want to come to challenge the jurisdiction. They are the challengers in that respect. And by virtue of being the challengers, of making some assertions, they do take on an evidential burden. What distinguishes this case is that that stage has not been reached. And it would be perhaps tempting to say, well, we should consider that in fact, we should deem that to have been the case. But that takes on a dangerous tenor, because then jurisdiction becomes a matter of, becomes a deeming issue, where an administrative direction is made by a judge across whose desk has come an application for permission to serve out, and that would get into all sorts of tricky territory. So it's very important that there is a fundamental distinction between the defendant who has been, in respect of whom there's been an order made and who has been served, who comes to the court to seek to displace that, and an individual who is not a party.
Your clients weren't obliged to participate in these hearings. You pick your time, but it'd be interesting to know what complications you say would have followed had they just stood by and watched the process and seen whether the court made a decision in favour of the claimants instead of doing what they did.
Yes, my lord, I hadn't planned to deal with that hypothetical, but I will.
No, don't deal with it out of order. Just take your time.
I'm grateful. I will wait with it. There's no particular order in which I would want to put it, because I haven't thought about it, but I will, my lord. Thank you. What I have sketched, though, I think, is and it is hypothetical, but it's highly relevant, of course, is what would have happened but for the intervention of Mr. Justice Nicklin. And again, I emphasise, we don't complain about that because we see there is practical sense in it. And those of us experienced in these matters know that there repeatedly arguments about full and frank disclosure cloud the real issues. And so a process by which jurisdiction can be dealt with on notice is very attractive. But we said it shouldn't change the substance of what was being done. So I'll just go on, and I'm about to get into a little bit of evidence. Before I do, just on the procedural framework governing the claimant's application, there's no dispute as to that in its broad sense. So I'm not going to dwell on it, because one could spend a long time on it. It was an application for service out. He was required to demonstrate the relevant matters, the gateway, merits limb, and the most appropriate place. I'll put those in very summary bullet form. This was a sprawling claim. The court will have seen that it was, the particulars of the claim are hefty by the standards of the jurisdiction, the media jurisdiction. Every conceivable media cause of action was taken, from defamation to harassment. And this is for a handful of news publications. Misuse of private information, GDPR, you name it. It was like the contents of Gatley. It was in there. And it took a great deal of unpicking, both for the defendants and the judge, to get through that. Most of them were challenged on the merits limb. And despite the trees, there was fairly little wood. That's getting the analogy the right way around. And that takes us then to the Section 9 issue, in the context of the framework, and where it sits. And the judge characterises Section 9 as a modified replacement of the convenience test, the third issue in my summary list, in the context of a libel claim. That's at para 113, his judgment, at page A117. Neither Mr. Callis nor I quibbled with that characterisation when it was discussed below, and neither of us have filled in relation to it. But it's of some significance. That it would have been possible for the defendants to have tried to fit Section 9 issue into the merits limb. And in fact, it might be said that it ought to go there, or even in the gateway. Because if there's no defamation claim, no jurisdiction to hear a defamation claim, it's difficult to know what the cause of action is that he's relying on. Equally, if the court doesn't have jurisdiction to determine the libel action because of Section 9, the merits limb wouldn't be satisfied either. It cuts across all three. But the slight drawback of characterising it as a modified replacement, replacement is the word in inverted commas from the judgment, of the convenience test, is what to do with the body of case law that's grown up in relation to convenience when faced with the statutory wording of Section 9. And that is a significant issue. That is probably why we're here, because it has caused a fair degree of confusion. In a sense, I don't have to resolve that before your lordship, because I say that on any basis, the claimant had not provided sufficient evidence to satisfy the court, wherever the Section 9 issue is placed. That's my primary submission. Just looking then at the evidence that was provided. So the claimant served a witness statement in support of his original application to serve out. That's at tab 4 of the supplementary bundle. The libel claim is dealt with, it's worth turning this up, paragraph, so So I'm in, for those of us on paper, and if anyone is on paper, yeah, I know it is, the first of the supplementary bundles, behind tab 4. And the page number is 43. This is the claimant's evidence. It's worth bearing in mind that this was provided for the purposes of a without notice service house application. This is the claimant's evidence in relation to libel claim, paragraph 15. The publications in each of them are defamatory and have caused or are likely to cause serious harm to the Mr. Soriano's reputation, harm not least due to the gravity of reputations and substantial publication within this jurisdiction. So that, there you have it. That's the extent of the evidence on the libel claim. We say that's not a great deal. Flicking through that statement on to page 47, we say this is significant. What he has done is identify with some particularity.
When you say page 47, do you mean on the electronic or?
It is B47, so it's going to be 3 pages further on than we were, maybe, paragraph 22 of the statement.
22.
Is that in fact the internal of page 47 on the PDF?
I think there's no disparity actually in this bundle between the electronic and the physical. Hurrah.
So I'm at paragraph 22.
Yeah.
You'll see that whilst he's said fairly little about himself, I'll comment on what else he said about himself in a minute, he's been able to deal with some detail with the defendants and where they are, the jurisdictions in which they live, looking over the page. Because he needs to say where he wants to serve. And then that England and Wales is the proper place is dealt with at paragraph 34, which is at page 50. And paragraph 34 is a sort of self-serving, and I don't mean that disparagingly, I'm seeking to be descriptive, a self-serving list of reasons why permission ought to be given. Of course, naturally focuses therefore on damage in England and publication here and Mr. Soriano's connections to the jurisdiction. What it doesn't do is raise the issue of section 9, the issue of the locations, places in which, other than England, the articles were published, which one would expect to see. And when we look at a Hooja later on, you'll see there, and it is our case, that expectation is in fact a legal requirement. So then, moving on over the page to 2 pages to page 52 of paragraph paragraph 41 under the heading Full and Frank Disclosure. We find a sort of partial account in relation to section 9 factors. when we come to look at section 9, but I'll remind you now, we will see, of course, that, and the case law on it, that the claimant is expected to put before the court evidence of his reputation in most obvious jurisdictions where material has been published. And in this case, that would include evidence as to his business interests and links to those jurisdictions. And this is his opportunity on a sort of frank basis to do so. And it's really the matters at 41.1 and 41.2. And then quite extensive evidence of where he's been litigating in this and other jurisdictions. But of course that begs the question, why is he litigating, in defamation I should say, or at least in personality right cases, why is he suing in Israel for global publication if his reputation is here? And he sued the 6th defendant a number of times in Israel. So he clearly considers, reading between the lines, that his reputation extends beyond the UK and certainly into Israel. We learn from those paragraphs 41 and 41.1 and 41.2 that he owns property in the United States, that he has a United States business partner. Sorry, those matters are not where I said they were. They're at 52 and 53. Paragraph 52 and 53. Sorry, they can't be. They are where I said they were. Big one. Paragraphs 41.1, 41.2. US business partner, and he owns property in Israel. And then he's brought these libel actions in these various jurisdictions. Now, of course, would be perhaps nitpicking to criticise him for litigating in Ireland in relation to the social media and tech companies, because that is where, for reasons of tax and data protection law, they've chosen to seek themselves for European purposes. We don't say that means he's got a reputation protected in Ireland. But we go so far as to say this: he has, on this evidence, a reputation that extends well beyond these shores, but he doesn't say what that is. Say that he owns properties in Israel. That cannot have been a secure basis for him to have launched those defamation actions against the 6th defendant in Israel. The simple fact of owning property there. So, again, we say that this is not really the sort of evidence that one would expect to see on a Section 9 application. At least not one that's expected to succeed. And perhaps this is now a moment in which to speculate as to what would have happened if this application had gone before, let's say, a master. This is my Lord Warby's point on this is that if it succeeded, and they'd served this evidence along with their order and the note of the hearing, a skeleton argument, on my clients in the US, it would have been, not to say it would have been a no-brainer, but it would have been, the primary piece of advice is likely to have been, he's not done enough here to satisfy Section 9. And if the order has been made by the master, it's been made in error, partly because of his failure to give full and frank disclosure, because there are so many gaps in his evidence. In fact, those gaps are demonstrated.
Just to spell it out, you assert he hasn't done enough to satisfy Section 9. Why not? spell it out.
Because he has not ruled, and I'll deal with this now. But again, I'll ask you to remember the submission when I deal with the case law. He's required by the case law to put before the court evidence of his reputation and interests in jurisdictions where substantial publication is likely to have taken place.
Well, that's what you say he's obliged to do, but where's he failed?
Oh, I see. Well, we say that his evidence in relation to his US interests is absent. Well, I'm going to come on to deal with some of the evidence that was served on my client's behalf, which demonstrates that he has an international outlook and international business interests that simply weren't mentioned at all. We say that he must have a reputation in Israel because he's sued there, and he hasn't dealt with that at all. I mean, one of the substantive allegations, we don't need to get into this at all, it's no doubt disputed, is his proximity to political leaders or a particular political leader in Israel, let's say. I don't need to say more than that. Now, he just mentioned that, he doesn't have to deal with the underlying allegations at this point. But it's surprising that he's able to say, I've launched several defamation actions in Israel, I own property there, say nothing more about my reputation in the jurisdiction or any other. So that is the default. It'll be a bit more particularised when we work our way through the evidence. It might have been helpful to have had a sort of heading, section 9 in the statement. There isn't one. I'm not going to criticise whoever drafted it for failure to use a heading, but it sometimes helps to structure things according to what you need to prove. So then, the defendant served a statement in response. And that is behind the next tab, it begins at page 59. Of the same file. So there is, I'm going to flick through it, and I'm not going to dwell too much unless we have to on any particular element. But there is background to the first defendant, at paragraphs 12 to 23. Paragraph 25. It said what the first defendant's sort of interests are as a publisher. They are, we would say, US-centric. They deal with US security and political matters. Then at paragraphs 24 to 36, you've got details about the publications and who was responsible for them as between the defendants. Then there are detailed biographical sketches of the individuals from paragraph 46 onwards. So, page 70, you'll see the evidence in relation to them. Of course, our case is that this is all voluntary. But I would ask that the court reads it and bears in mind the tacit nature of the claimant's own evidence in relation to his biography. Here we have relatively detailed biographical account of the second defendant, who is the man behind Forensic News, the third defendant, page 71, and so on. Running in this section alone to some 6 pages. And in that evidence is described how none of them have any connections to this jurisdiction. Some of them have been on holiday here for a week, and that's it. Then there's really sort of granular detail from page 80 onwards. It's called Audience Statistics, the website and publications, which I'll skip over for the time being. We will come back to it, but perhaps not in my opening. Then, from page 107, there's a section dealing with the Section 9 matters. There's a complaint at the top of page 107 in E, actually 158E, that the claimant has produced no evidence that the source of his business derived predominantly from individuals and or companies based in the UK. In fact, claims an international businessman with clients all over the world. On his own LinkedIn page, he lists business partners of his company, USG Security Limited, including Sochi Airport in Russia, FIFA, many prestigious football clubs, several airlines, 10-year contract providing security to Mexico's largest steelworks. And then there's some detail discovered by those instructing me about a contract in Israel. And it's noted, obviously, that the claimant was a person of interest to the US Senate Intelligence Committee. This implication being that he has some connections, or is perceived to, by that committee to have connections to the US political scene. And noted also that he's a family friend of Israeli Prime Minister Netanyahu, which I think is in fact averred by the claimant himself. Placing his jurisdiction, or at least extending it well beyond. And then there are claims in F about a network of companies that he controls. Some of those are disputed by him in subsequent evidence. Some isn't. So those are the sort of Section 9 matters, doing the best that the defendants can in the circumstances where they are not parties, in circumstances where no disclosure obligations have kicked in relation to either them or the other or the claimant. Whilst there are no disclosure obligations, it cannot be said that the defendants allowed the claimant to sort of walk into a Section 9 trap, if I can put it that way, because on the 24th of November, first of all, they served this statement. But secondly, on the 24th of November, they wrote to the claimant's solicitor. And this letter, I will ask you to turn up, is the last document in the supplementary bundle. So it's going to be in file 3 for those on paper, and it's going to be page B839 for those on the screen. Now, having completed their preliminary research into the claimant, recognising that he appeared to be a man of, with an international remit, it was natural for them to wish for him to set that out, that remit.
Can you just remind me of the date of the witness statement we were just looking at?
I can. It was it's going to be the 30th of November. So in fact, my chronology is slightly out, for which I apologise. This letter was sent prior to that. So, that might have mattered if it had been answered. But it wasn't. You'll see then that fairly detailed questions are put. Initially, I mean, it includes questions about Russia, presumably because of the Sochi airport contract. But pertinently, the claimant is asked to deal with his connections to the US in fairly pedestrian fashion. He's asked simply to say how often he goes there. Obviously, what interests he has there, and so on. It's a perfectly proper question to ask. How much time have you spent in my jurisdiction if you want to sue me in yours?
That's pretty wide-ranging questions there.
Yes. Okay, again, if complaint returns that they were too wide, perhaps the argument would be different, but this was just ignored, this letter. And no attempt to answer these questions has ever been made at the level at which they're asked, or any other level, except my lady, they aren't quite. But again, the defendants have fairly limited knowledge of the claimant. By the claimant's own assertion, he is extremely private and wishes to remain so. It's a matter for him. It's a matter. He nevertheless cannot escape his responsibilities under Section 9 simply by saying, well, I'm very private, I'm not going to tell you about my global reputation, about where I do business, about where your articles are going to cause me damage. And these illustrate, these questions, however broad they may be, they illustrate the areas that needed to be populated with particulars.
Does it follow that you're saying that the absence of this information in the witness statement was a failure to provide sufficient information?
Yes, my lady, it does.
In relation to all of these categories?
No, what we say, we say that the failure is to give evidence as to the business interests and reputation in countries where the articles are likely to have substantial reach.
So which questions do those go to in this letter?
Well, the difficulty we're in is that the questions are directed at focusing his mind on answering the questions that I've just put.
I understand that, but which are the material questions for this purpose?
So they are, well, we would say all of them, to the extent that they had an answer that he was able to give. Of course, one has to sympathise to a degree. Here's a man seeking vindication for his reputation. He's a private man, and being required to divulge more about himself than he would like to. But that, unfortunately, is the regime. That is the requirement. And we know that, and Mr. Soriano's lawyers will have known, that there are mechanisms by which particularly sensitive information may be protected, despite the open justice principle and its near sanctity. And he could have attempted to use those mechanisms were he so concerned that any of these answers were sensitive.
Which mechanisms do you have in mind?
He could have sought, well, he could have sought to, so first of all, he could have sought to seal any evidence which he said was confidential. He could have sought orders which I accept he may have thought were of limited value in the circumstances, but he could have sought orders that information, including information given to the defendants, be treated as if it were governed by Part 31 and the...
the writ doesn't run.
But he could have sought an order to that effect. Again, we're in slightly uncharted territory because, of course, had he applied without notice, got permission, and the defendants were then seized, the court seized jurisdiction of the defendants, he could have sought an order, albeit that exposure hadn't been required yet. He could have sought an order in identical terms to 31, to the undertaking in 31 to 22, that they not use the material save in relation. But one can also imagine other mechanisms that might be devised. Difficult, I accept, in these odd circumstances, but no attempt was made to do that. The response was radio silence on these questions. So, again, had the application been made granted without notice, these failures would almost certainly have entered the defendant's thinking in deciding whether or not to challenge on both grounds, on both full and frank grounds, and on failure to satisfy Section 9. I'm going to move on, if I may, just simply to note that there was responsive evidence to the Doris statement. It is mostly taken up with complaint that Doris' statement served, I think, a matter of minutes or hours out of time, and the need for him to apply for relief. It does include some bare denials in relation to some of the facts alleged. I'll take it. It's at B118. So we're going to be in tab 6 of the first file of the supplementary bundle. And as I say, clicking through, it deals with the need apparently for relief from sanctions. It deals with publication in a fair bit of detail. Views of the publications, which is really just a reanalysis on page 114, 115, 116, a reanalysis of the information already provided by the defendant. A Reddit ban in relation to second defendant, relevance of which isn't clear. And then paragraph 31 of B118, a single 4-line paragraph headed business interests, seeks to engage. Now this is in context of the Doris statement with extensive interest, evidence in relation to the claimant's foreign business interests. Some speculation again because there's a lot that's not known. And the answer is very narrow, very carefully worded, 4 lines, picking up those 2 minor paragraphs in the Doris statement and making some specific bare denials. He doesn't deny everything that Doris has said, he denies a couple of things. That's it. So, it's not surprising, therefore, that both judges below, both Mr. Justice Jay and Mr. Justice Johnson, commented in fairly stark terms upon the claimant's lack of openness in relation to his global interests and reputation. Of course, what we're really interested in is what is the consequence of those comments. What should that consequence have been? And with that, if I may, I'll turn to deal with my two grounds of appeal. Before I do so, I will turn up the statute itself. Okay? So we're in the Appeal Authority bundle, in the first volume of that. And it's behind tab B, and it is page 30. I just want to make a couple of observations before I then get into my grounds. Here it is. This is what we're working on. Section 9. Two short points about it. It applies to the action, not the person, and not to service on such a person. Both subsections 1 and 2 are clear in that regard. This section applies to an action for defamation against a particular class of person. And a court, it is concerned, section, with jurisdiction to try the action. It is not concerned with service. Then in subsection 2, the court does not have jurisdiction to hear and determine an action to which this section applies. It doesn't say service may not be effected upon a person who's domiciled outside of jurisdiction in certain circumstances. It says what it says. So our ground 1, and these are in our appeal scale argument at this is paragraph 15, and I won't turn it up, but if you'd like to, then I will give you the reference. Fact. Maybe simpler. To access it from the notice, which is at A14, the grounds are set out in single document. So that's behind tab 1 of core. The judge was wrong to hold. When a court is considering section 9 of the 2013 Act, there is an evidentiary burden on a defendant to show that another forum is available and appropriate. Now, we say that he was wrong in any event, because, and you'll be aware that we go on to argue that, because he's dealing with subject matter jurisdiction, not person jurisdiction. But just descending for a moment back into the nuts and bolts of the instant case, we say he was particularly wrong. That isn't like being particularly pregnant, because in these circumstances where these defendants were not parties to the action, and I've explained what the unfairness we say that gives rise to, and why it's procedurally wrong. So the starting point is that he was correct to hold, we say, that Section 9 is a distinct parallel regime from that governing personal jurisdiction. And he also correctly identified that, again, agreeing with submissions made on behalf of the defendants, that the reason why it can be a distinct parallel regime from that governing personal jurisdiction is because it deals with different species of jurisdiction, namely subject matter jurisdiction, because it is qualitatively the same as the jurisdiction which is the subject of Section 10. It is therefore qualitatively distinct from personal jurisdiction. And I mean, that is the fulcrum of our argument, because from that starting point, one can avoid having to follow strictly authority on personal jurisdiction cases. It is of assistance, but it is not binding, we say. And once the judge had correctly held that he was dealing with a distinct parallel regime from that governing personal jurisdiction, because it's subject matter jurisdiction, it was wrong as a matter of logic, say, for him to hold there was any burden on the defendants, because it is always for the claimant to assert and prove in relation to subject matter jurisdiction. Subject matter jurisdiction cannot be waived and must, if raised, be dealt with. So going back then to the first case on Section 9, I'll get into the authorities just a little bit now. And then that first case is a case called Ahuja and Politica, and it's found at, I think it's the tab 8 of the appeal authorities bundle, which is for those of us
Tab 9.
files. Tab 9, thank you, my lord. Tab 9, it is the first tab in the second file. This is a case decided by Sir Michael Tugendbach, 2015, and this was the first time that Section 9 had been deployed. This was a case in which a Serb newspaper and its editor and a journalist were sued in London by a man of international status who had chosen to make his home here. A personality that is relatively familiar to the defamation cause. Now, there were, as was predictable, there were inevitable issues of material non-disclosure. The businessman turned out, having said in his evidence that he was of Indian origin, it turned out he was in fact half Serbian and owned significant property in Serbia. And he hadn't told the court. And that was discovered by the defendants, put in evidence by them. So the thrust of the application was on material non-disclosure, but it wasn't only on material non-disclosure. Substantive Section 9 issues were considered, and this being the first time a point had been taken on Section 9, and because the court was assisted by the presence of even then senior Libel QC, Hugh Tomlinson QC, who made principled arguments about Section 9 and surveyed all the then available commentary on the section. The court grappled quite comprehensively with the issue, and we say got to the right answer at the first time of asking. I will deal further on in my submissions as a sort of postscript with the issue of what is called libel tourism and why it's not relevant. I want to put that to one side, but it does crop up now and then in these cases. But I will make a couple of submissions about that. Nevertheless, libel tourists or not, there is a class of international person that often base themselves in London for many purposes and have done so for many years and have families here. Some of them are born here but have travelled so much that they are people of the world. That class of people, like any other class of people, may need the services of a libel, called an English libel, quite properly. And Sir Michael expressed sympathy with that class of people when faced with the terms of Section 9. Nevertheless, he was clear as to the consequences of Parliament's drafting. So this now, I think it's worth reading, if we may, or looking from paragraph 67 of the judgment. So that is from page, it's internal, well, bundle page 320, or maybe 321, given the insertions. If you're looking at
Sorry, what are you looking at now?
so page, it's paragraph 67 of the Abuja judgment, my lady,
Paragraph.
which I've got on page 320. Issues arose about a fair trial in Serbia, which were disposed of fairly quickly. The claimant had raised the issue without following through with proper evidence, as sometimes happens. And then if I could ask just to read from 67, the operative paragraph, the one I'm keenest on is 71, it's the one, the tram line, but I think the lead-in is on the systems. This sentence towards the end of 71, if I may, which has the practical consequence that we contend for in this case, and whether Parliament intended this consequence or not. The court can only do anything about it if, and to the extent, that claimants put before the court the evidence of the harm to their global reputations which enables the court to be satisfied of the Section 9. The court can't do anything about it if the claimant doesn't do that. The court can only do anything about it if the claimant does. It's an axiomatic proposition.
You wouldn't draw no distinction here between somebody who is a UK citizen, as it were, and somebody who is a resident?
Not necessarily draw a distinction, no. I mean, it's a multifactorial issue, my lady, and being a UK citizen, not having left the UK and having no international business interests would, if put in evidence on a Section 9 application, would probably stop the inquiry. The problem is when you have individuals with undoubtedly an international outlook, with business interests all over the world, grew up elsewhere, as in this case, in another jurisdiction, who then fail to put in evidence of their reputational business interests in those other jurisdictions. That is when they fall down on the requirement identified there by some. I should note in passing that in Ahuja an argument was raised, it's not raised, at least not with any gusto before this court, and that is that Section 9 might offend Article 6 of the Convention because it restricts access to the court. For your note, my ladies and my lord, that's dealt with by Michael paragraph 33 and following from page 312. He rejects it. I don't understand it to be raised again in this. Just putting the authorities to one side for a moment. One thing everyone can now agree on, because Lord Sumption said it in the Sher appeal at the Supreme Court, is that Section 9 modifies the law of defamation. What Section 9 does not do, save perhaps indirectly, is modify the common law of interlocutory jurisdictional applications. Now, it might affect the substance of those applications. It does affect what the claimant is required to demonstrate. It doesn't affect the law on those. It doesn't affect the procedural law. What it does is modify the law of defamation. And it does that in the same way, using the same mechanism, in relation to both Section 9 and Section 10. Same device is used to modify law of defamation in Sections 9 and Section 10. They're expressed in relevantly identical terms. And here we would do well to go back to the statute. So I'm going now to tab C of the first file of the authorities bundle on the appeal, and to page 45 of the. Sorry? Is 10 in there? I think B, yes. Oh, thank you very much. So we can go to B, it's going to be easier to read, I'm grateful. Where we were before, page 35 of that, where we have both 9 and 10 set out. Section 9, actions against person, action against person not domiciled. This section applies to an action of defamation, and then subsection 2, a court does not have jurisdiction. That language is repeated at section 10.1. A court does not have jurisdiction to hear and determine an action for defamation brought against a person who is not the author or publisher. There's an interesting, potentially interesting distinction between the two sections, which is that section 10 is not introduced in the same way that section 9 is. Now that's probably because there is some importance to the territorial scope of section 9.1, Simon was drafted, and that importance continues, albeit for reasons, because it's been amended now to remove B and C. But anyway, we say that functionally they're the same. They deal with subject matter jurisdiction. And they're distinct from the requirements in the service out regime. They're both in mandatory form. We say that the court must consider section 10 in every relevant claim that comes before it. And it would be a rare case where that requires more than a pause. The majority of cases, publication, responsibility for publication is easy to establish, not to dispute. But there are cases where it is in dispute, and in such cases, Section 10 arises, the need to satisfy Section 10. And in such cases, the court must determine the issue. And we've identified a couple of early cases on Section 10 where the court, my Lord Warby, first instance, in decisions that weren't appealed, but the court has correctly identified that when dealing with cases in the absence of defendant, it is nevertheless still necessary to tick off, if you like, the Section 10 issue, because it may be that the court is operating without jurisdiction otherwise. And those cases, which we'll look at quickly, are Brett Wilson and Curtin Jackson. Brett Wilson case is in the first file of authorities at tab 8. For those that need to refresh themselves in relation to the case, the head note will do that. It's one of the solicitors from Howell cases, some bench, and not uncommonly in those cases, no defendant here. And then the operative paragraphs at 20 to 23. I'll ask the court to read. I'm going to pick out a sentence from 23 when we have a chance to do so. The feature that I've alighted on is this final sentence, 23. Court only had the claimant's pleaded factual case in relation on this issue, and was able to make the determination based on that. And we say that's quite proper, because it's for the claimant to assert and prove that. Had there been an evidential burden on the defendant, there would have been no need to consider the issue, because with the defendant not turning up, the issue would have been automatically, by default, decided against them.
It's a bit artificial because this was a default judgment application, and that by the very nature of it, the defendant wasn't turning up, and the case had to go on the pleadings rather than any evidence, because that's what the rules say.
And the that I accept is a distinction. The fact that this was governed by the rules and regulations. Nevertheless, we say this is an example of Section 10 in operation where no issue of any burden on the defendant arose. And the same happened in Pertec. Summary disposal, again in the absence of defendant. That's at tab 10, which is going to be in the second file. Before I move on, I accept the criticism that it is a bit artificial, your Lordship's words. We say it applies in any event. A little bit of artificiality, we say, doesn't defeat. So I'm in the second appeal authorities manual, tab 9, tab 10. Same circumstances. And the same result. The issue was raised at the court's own motion in both cases. And we say again that has to be right. In another case, this time Julian Knowles J case, Sadiq and Sadiq, which is at tab 14 in the same bundle. This issue was taken on more comprehensively. And it's at paragraph 51 to 57, where a passage that we say applies to our case. We say it's right, we say its application to our case indicates our position, we say you should adopt it. So I'll allow the court to read it. I simply cannot paraphrase it, I'm afraid, despite it being pages long.
Which paragraphs, 51 to where?
51 to 7, my lady, 51 to 57. So I will emphasise the sentence in paragraph 55. In my judgment, jurisdiction under section 9 cannot be conferred by waiver, submission or consent. This is because it had been submitted that unless a party uses part 11 to challenge jurisdiction under section 9 and follows also section 10, that right is lost. It's rejected because section 9 cannot be conferred by waiver, submission or consent. It's concerned with the subject matter of the suit and not with personal jurisdiction of the defendant. What is interesting about this, and for a moment, if I may, I'll park issues of Henderson abuse, but without any admission, they may arise. But we say this is right. And it follows, therefore, that absent repetitive or vexatious applications in relation to section 9, it is a matter that needs to be kept under review. And it is potentially a matter in relation to section 9 and or 10, which might change. That's more likely in a section 9 case. But things may develop in relation to the appropriateness of the place in which the case ought to be tried during the life of the claim. Or new facts or matters may come to light in relation to the claimant.
So you're saying that once the court might decide it had jurisdiction and later on decide it hadn't?
Yes.
So it was acting without jurisdiction during the time it asserted that it was?
That's a good question, my lady, which I have not considered. But at least in theory, it ought to be possible to do that. Because subject matter jurisdiction is only good so long as the subject matter remains, the quality of the subject matter remains at least relevantly constant. Where that submission, I accept it may lead to that surprising result, but where it is relevant to the particular circumstances of this case is that here the issue in section 9 has been determined against the defendants at a time when they were not parties to the action. And it may be said that they should not therefore have lost the right to raise the issue once jurisdiction has been established over them. If there are circumstances they wish to put before the court, they say change the calculation. This is the bind, I suppose, that they were in. Invited to voluntarily participate, did the best they could, sought answers from the claimant that were relevant to jurisdiction. He might have had significant interests in California, for all we know. They didn't identify where his US business partner, for example, lives and works. It might have been another relevant state, say New York. And if it subsequently comes to light that those facts change the calculation, the defendants ought to be able to bring those facts to the court. But this, of course, is why the claimant needs to be upfront about their global reputation from the very beginning.
Do you have a submission about the role of Part 11 in connection with Section 9 or Section 10 for that matter? I mean, it doesn't, although if Mr. Justice Julian Knowles is right, a failure to apply under Part 11 is not a waiver and doesn't preclude the question of jurisdiction, is a defendant who wishes to raise a jurisdiction point under Section 9 or Section 10 able to use Part 11?
I haven't looked at that precise question, but I mean, I see no reason why they shouldn't use it, but I see no reason why they should be restricted to using it. There are many examples.
No, but if it's a question of jurisdiction, in principle, it could be raised at any stage.
Yes.
And there might be consequences in terms of costs.
Absolutely. That is our submission. It can be raised
once decided in the context of the action, you would only be able to reopen it by way of an appeal or in the exceptional circumstances where you can revisit an issue first instance.
Yeah, and that...
But you say it's not been decided in the context of an action, it's been decided as a preliminary process.
Yes, and in any event, one may have to add a degree of elasticity to the exceptional circumstances proviso, but one can envisage circumstances in which strangers to the court are able to participate in a limited way at this stage, but when the matter develops, the litigation develops, and the picture changes, should be entitled to bring the renewed picture to the court to say, well, wait a minute, Section 9 matters have come to light, which were not previously known, and is no longer the case. The court should exercise its jurisdiction. Now, can exercise its jurisdiction. The point about what happened before that we get to that stage again is something I haven't been able to give any attention to. But that is the result, and we say that result is capable of being managed by existing procedure and costs, potential cost implications. If a defendant's conduct in that regard is deemed to have been tricksy, then no doubt they will end up paying the costs of the exercise. But with that we say is the result. So that's our ground one. We say there's no basis to import into the evaluation envisaged by sections 9 or 10 the good arguable case standard developed in the service case law, because that sets up a contest between the parties' respective arguments. And then I'll move on, if I may, to my ground 2, which I can take a little quicker, and a lot of the ground of which we have covered in one way or another. And that is this. Once the judge had accepted, had held, that the claimant had been far from forthcoming about his business interests, both here and overseas, there was no safe basis for him to conclude that England and Wales is clearly the most appropriate place in which to bring the libel action. Recalling Ahuja, and perhaps pausing quickly to look at writing there in the Court of Appeal. So that's at tab 15 of the authorities bundle, which is in the second file. And I would ask you to turn to page 452, which is internal. I don't know about the internal paper, but it's paragraph 58. For a sort of helpful review of cases between Ahuja and the right of their case. And then paragraphs 60 and 62 to 65. And I can, if you want to note those paragraphs, I can summarise them. I have been summarising them all morning. The effect, the relevant effect, is that it is for the claimant to satisfy the court, having regard to all the relevant circumstances, and that includes his interests, that England and Wales is the most appropriate place in which to stay. And if, given the circumstances of the particular case, another candidate jurisdiction emerges, as is likely in these cases, the burden remains on the claimant to equip the court to undertake the Section 9 comparison. It doesn't shift simply because the claimant has identified that he has a reputation elsewhere that might be relevant to a defendant. It doesn't suddenly require the defendant to pop up, at least not without notice stage, and produce any evidence in opposition. Simply because the defendant isn't required to assert anything at this stage, and therefore isn't, the maxim doesn't apply. He who asserts is proved. We say that if anything, the claimant's failure to produce the proper evidence, or to produce enough evidence, including if appropriate expert evidence, should have been dispositive in the defendant's favour, because such a failure on C's part prevented the court from conducting the relevant comparative exercise. And because it couldn't conduct the relevant comparative exercise, it could not be satisfied in relation to the Section 9 matters. There was another practical effect of the claimant's failure to properly particularise his reputation and interests, particularly as they related to the United States. That meant that even if the defendants were under any burden to identify a rival candidate for jurisdiction and deduce expert evidence in relation to it, they were not able to do so. They might have gone to the expense of producing evidence of Californian law, only to be told, well, actually, my business partner's in Florida. Had the claimant chosen to sue the defendants in the United States, which Mr. Justice Johnson found he could have done, at least both in the federal courts and in Washington, he could have opted to sue them in their home states, or in any state where he'd suffered loss and harm to his reputation. And the result of his failure to respond to the defendant's 24th of November letter in any way, whether precisely to the questions asked or in general outline, and to provide information to his business interests, dealings and assets in the US. His failure left the defendants in an impossible position. I remind the court that three of the defendants, including the corporate entity, are domiciled in California. One is in New York and one is in Pennsylvania. Should they have got together and decided amongst themselves on a single rival candidate jurisdiction? Should each have been free to propose their own? Or should they have sought the information to make an objective decision on the full facts in relation to the claimant as to where the most appropriate place was? That, we say, what should have happened, even if they were under any burden to produce expert evidence. But they were prevented from doing so. Thank you. I'm reminded, we'll come to it, but I'm grateful to Ms. Close for allowing me to correct this now, that Johnson J did find that it would be difficult to sue in the federal court So he held that the local state court of Washington could and would have tried the action, but he didn't make the finding that I had said he did in relation to federal court. So I'm very happy to make that correction. So here we have a situation that I'm developing whereby the judge is right. My clients were under a duty to discharge an evidential burden to persuade him by expert evidence of a rival candidate jurisdiction. My clients who at that stage were not defendants, not parties to the action, strangers to the court, individuals located around the US. It can't be right that in those circumstances the court should expect the cumbersome and expensive process of expert evidence to be entered into. We say that is a very real practical difficulty if it remains the case as held by Mr. Justice Jay and followed by Mr. Justice Johnson that defendants in these circumstances are required to produce expert evidence. Now I accept if the order had been made on a without notice basis and my clients had come to the court and said, hang on a minute, this isn't the right place, I'll tell you where is the right place, then there may have been some burden on them to produce evidence in that regard. It would still have been for the claimant to satisfy the court on the legal way. But we're not in that territory. So that's my second ground. Before I finish, I want to make a couple of general points. Firstly, I want to comment quickly on the claimant's case on the evidential burden. He relies on 3 cases to support the proposition that an evidential burden applied. And he will take you to them. So I would ask you to bear in mind that none of the cases on which he relies is on all fours with this case. All of the cases on which he relies assume that the defendants are a challenger in some way to a decision taken by the court. That's in Unwired Planet. Or that they must prove anything in the exercise. That's in the AstraZeneca case. Here, there is no burden on the defendant to prove anything. But the defendant's involvement, as I've said, at this stage was an accident of the approach taken by Nick Jay. They were not challenging a decision made by an English or Welsh court that England and Wales are the most appropriate forum, because no such decision had been taken. I'll now turn to deal with the issue of libel tourism, which I'll take fairly quickly. It's really a curio rather than anything substantive, but you'll have seen in many of the discussions about the origins of Section 9 that it was apparently drafted in response to perceived libel tourism, and that is variously described. But it seems that its core elements are essentially a foreign-based claimant seeking to sue a foreign-based defendant in these courts, or the courts of England and Wales. And in its true sense, I think that is what libel tourism is. But in the cases on which I rely, well, the primary case on which I rely, which is the Ahuja case, it was not alleged that the claimant in that case was a libel tourist. He was resident and had been a resident in this jurisdiction for many years, had a family here, and that was accepted. But it remained the case that he was a man with an international outlook. But in any event, it's a red herring, libel tourism issue, because as everyone agrees, including Sir Michael, as I've just pointed to, the effect of Section 9 is in fact much wider than the mischief of libel tourism, and we are stuck with it. The defendants don't allege in this case that the claimant is a libel tourist. They may complain that he seeks to make them unwilling libel tourists by forcing them to come here when they've only ever been here on holiday.
I think that's been described as libel kidnap.
Okay. It may be so described again, my lord. It's a red herring, as I say. It is not in any event necessary to look to the purpose for which Section 9 was enacted, because its drafting is clear. Whether we disagree about the effect of the drafting, where we place it in context, how it applies to this particular case, are all, of course, in dispute. But I don't think any of us could say that it is not clear in its drafting. At least that has certainly not been said on the other side. So I would ask you to put that to one side and ignore it. Just a couple of observations on the sixth defendant's case, although actually I have commented on it already and corrected on it. And my note here is in fact correct, so I will go back to it. So the Mr. Silverstein, the sixth defendant, did produce expert evidence of federal law and the law of the state of Washington, and was able by that to persuade Mr. Justice Johnson that Washington was an available forum for the libel claim. And save in one crucial respect, more appropriate than England.
What are we to make of that in this context?
What do I make of that in this context?
What are we to make of that in this context?
Yes, I mean, this, my lady, and I think this is the submission that underpins my ground too, which is the sort of practical effect of it being for the claimant to assert and prove, not for any defendants. The case against Mrs. Silverstein has gone in circumstances for which we're not aware. It's been settled. But in any event, Mr. Justice Johnson held that this was not the most appropriate place in which to try the action, save that the action in relation to my clients was proceeding here. Had it not been for that factor, he would have kicked back the claimant's claim against the sixth defendant. And we say in those circumstances, it can't be right that Mr. Silverstein should have expended, and he did so, he obtained expert evidence following Mr. Justice Jay's judgment that our failure to do so was a significant factor in his appraisal. So it's not surprising that he did it. But the huge volume of evidence and expense required by Mr. Silverstein to persuade the court that this was not the most appropriate place, we say is inappropriate against a defendant or against a person who is not a party. And that setting the expectation for non-parties at that level is not fair. And I can't actually put it any more eruditely than that. But for reasons that I hope are obvious, it is not fair to expect them to go to that expense. And in fact,
they're not if they are responding to an order of the court.
I think once they become a party, we are looking at other mechanisms for controlling the fairness of what they may have to spend. Now, again, so we don't know the circumstances under which his claim settled, but it doesn't appear to have been unilaterally withdrawn by the claimant. So, If I just ask you to note the repeated complaint by Johnson, J, about the scant, what he describes as scant evidence is to damage your reputation. It's his judgment, paragraph 83, his judgment is at B764, at least that paragraph. I've made that point previously. So just draw to a close within my allotted time. You'll see in our skeleton argument we make short submissions on disposal of our appeal. If court is with us, we say it can and should declare that the English and Welsh courts have no jurisdiction to hear and try the claim because the claim has failed to satisfy the court in relation to the Section 9 matters, and that would lead to the dismissal of the claimant's application for permission to so allowed. I think I've dealt with my Lord Warby's question about what they would have done. And in fact, it's cropped up repeatedly what the defendants would have done had Mr. Justice not intervened and had an order been made by a master.
But that's a striking procedural feature of this case, isn't it? That this was, as you put it, an unprecedented procedural route that was followed. I was just trying to see what was said about that in the judgment. From my recollection, relatively little.
Likewise, it was a circumstance that everybody, speaking with the two advocates, say this, but everyone, including the judge, acknowledged it was unusual and then got on. But we say that his approach, nevertheless, has led to this unfair result. On my terms. Now, unless I can assist any further.
Thank you very much. Yes, Mr. Callis.
My ladies, my lord. I'm going to begin just with a handful of facts, and I'll go to the evidence shortly afterwards. But I'm reading from paragraph 1 of the particulars of claim to begin at the beginning. The claimant is a British citizen, naturalised in May 2009 after moving to the United Kingdom in September 2003, although he's also kept dual Israeli citizenship, is both domiciled and habitually resident in London, is domiciled in the UK for tax purposes, is the director of 7 English companies, all of which are domiciled in London, and his professional life is centred in London. His immediate family, 8 of his 9 children, and all 7 of his grandchildren are based in the UK, with his 9th child due to move to the UK from Israel in the near future. And it talks about the Brussels regulation, because Article 6 is the beginning of the framework. In those circumstances, the additional trusts and companies that were raised by the defendants in evidence that were flatly denied to be owned and controlled by my client in our response evidence, and in circumstances where he admitted his passive investments in the United States that he didn't manage and had never visited, he disclosed the litigation in Ireland against the social media companies who had domiciled there under Article 4 Brussels. And he also disclosed the litigation he had brought in Israel, his other citizenship, against Israeli defendants, which the Israeli courts, at least as against D6, had held that they were not forum companions against American defendants. That was the context of what was being brought in this jurisdiction against other American defendants. And we say against that fact base, it was thoroughly unsurprising, especially in light of the agreement between the parties on the evidence that my client was essentially a ghost online. He wasn't an international movie star or even Dr. Wright, let alone a Boris Berezovsky. He was a ghost online. He had commented only once in the Anglophone press before the Senate investigation. It should be of absolutely no surprise whatsoever that he is the first claimant to successfully hurdle Section 9. It is a provision that was designed, although it can apply to UK domicile claimants, it was designed to catch libel tourism. The defendants concede that my client is not remotely a libel tourist, And so it should be of absolutely no surprise whatsoever that he was successful on the facts before Mr. Justice Jay, who held paragraphs 140 to 142 that he did not have that sort of global reputation. So Mr. Justice Jay was satisfied that England and Wales was clearly the most appropriate place for my client to bring a claim. The question for this court is whether he made an appealable error of law. Now, I pause there in my speaking note because this morning you heard a case that wasn't made before Mr. Justice Jay, and it doesn't appear in my learned friend's grounds of appeal, nor did it appear in his skeleton argument. We had come into this appeal thinking that there was a major dispute in the two major instances where jurisdiction is raised. That is to say, a CPR 11 to set aside a service out, where everything's heard again de novo, or alternatively, where there's been service as of right, a CPR 11 challenge, really on foreign non-convenience grounds. And in either of those challenges where Section 9 would be engaged, there are interesting questions to this court about subject matter versus personal jurisdiction, burdens and standards of proof and the like. I think towards the end of my learned friend's submissions, he actually conceded that had this been one of those normal cases, either of those normal cases, including an application by the defendants to set aside service whereby this would be done de novo, I think he conceded that there might well be evidential burdens because of the binding authority of the Supreme Court in unwired planning. And as I understood the case, the novel case that was made this morning, the reason that his clients are under no evidential burden is purely because of the procedural novelty introduced by Mr. Justice Nicklin, whereby he made an order of the court that the order and the application with the pleadings attached should be served on the defendants in the United States, and they were indeed served, and there were affidavits of service below. So before the claim form was served, the original process, if you like, for the application was that the application notice, including the pleadings, and the order of Mr. Justice Nicklin was served by process server on all of the defendants. The basis this morning, it was said, that there was no evidential burden, is because of that procedural novelty alone. Now, there was no application within time or at all to set aside the order of Mr. Justice Nicklin. There was no appeal from the order of Mr. Justice Nicklin. No objection was ever taken. The defendants chose to put in evidence and to fight the application that had been served on them overseas under the CPR on notice. Nothing was said about it at the hearing. It's not raised in any of the grounds of appeal. And the only mention of Mr. Justice Nicklin in my learned friend's skeleton argument is paragraph 8 that merely notes the procedural novelty. But this morning is the first time we've ever heard that anything hinged on the difference between that and the more conventional ex parte service out and then application set aside, which is still done de novo. I'm afraid so, I'm not entirely in a position to deal, I will attempt to deal with the court's questions as best as possible, but this is an entirely new case not raised below or in the grounds of appeal or skeleton. So you'll forgive me if I continue with my submissions on the appeal that's actually been lodged with this court rather than the one that was necessarily raised this morning. We say that Mr. Justice Jay did not make any appealable errors of law, at least not in favour of the appellants. We say that he was perhaps a little too generous to their case, either on the absence of expert evidence, but also on the standard of proof. And there's an opportunity for this court, we say, to correct those marginal errors in the appellant's favour. But Mr. Justice Jay's generosity couldn't solve and couldn't save the defendants from two particular favours. It's not just a failure to put in any evidence, and certainly any expert evidence, on the availability or indeed the appropriateness of another court and another jurisdiction, its system of law, its remedies and the rest of it. It was the failure of these defendants to even identify the alternative forum that the comparison should be conducted as against England and Wales. The closest my learned friend came in the hearing below was to say, at what a state in the United States. There's no distinction in state or federal courts, and certainly no evidence on that. It wasn't even ascertained which state we were conducting the comparison. Mr. Justice Jay fell back on California, because when saw the publication numbers in my solicitor's second witness statement that showed publication by jurisdiction, California and England and Wales vied pretty much head-to-head on about half of the publications sued in libel apiece. California was the only US state to have comparable numbers to England and Wales on publications 2 to 8, And so he worked on that basis. But the defendants didn't even identify the alternative forum for the comparison. And they say, and it's very difficult to see why the procedural novelty introduced by Mr. Justice Nicklin would make any difference here. They say there's no evidential burden on defendants to do so. We say that's obviously wrong, both as a matter of law, but also as a matter of principle. Just turning to the grounds of appeal, which are on page 14 of tab 1. The second, which was, I think it's fair to say, the focus of my learned friend's submissions, was the perversity challenge in ground 2. But I'm going to begin, if I may, with ground 1 and the 2 grounds that we raise in our respondent's notice. So ground 1 is that the judge was wrong to hold that when a court is considering Section 9 of the Defamation Act 2013, there is an evidential burden on the defendant to show that another forum is available and appropriate. I think it's the availability is the evidential burden that he actually found, and certainly the one that we impressed upon him. Turning to page A17, our respondent's notice introduces 2 further grounds by respondent's notice that the learned judge was wrong to hold that, whether by analogy with Section 10 of the Act or otherwise, that the standard Section 9 of the Defamation Act in an interlocutory jurisdiction challenge is the balance of probabilities rather than a good arguable case. And secondly, the learned judge was wrong to reject the submission that expert evidence on the availability and appropriateness of an alternative forum is a necessary condition for the comparison required by Section 9 of the Act. So there are 3 grounds that, if I may, I'm going to deal with compendiously. Our 2 grounds of the respondent's notice and the first ground of appeal. My ladies, my lord, there are 2 very different versions of Section 9, which both parties accept should be construed harmoniously with Section 10. But there are 2 very different versions of events that have been put forward this court this morning. Our case is that Section 9 modifies forum non-convenience, whether that's in the service out procedural venue, or whether it's on a CPR Part 11 challenge. Wherever forum non-convenience arises, and this question of where is the clearly most appropriate place to hear the claim, if it is a defamation claim, we say Section 9 modifies forum non-convenience in respect of personal jurisdiction, and essentially it firms up the existing test, but in favour of forum domiciled defendants. By analogy, it works in that sense, somewhat similarly perhaps to Section 12 of the Human Rights Act in relation to interlocutory injunctions. American sign of it still applies, but the threshold where freedom of expression is engaged is raised by statute. But the rest of the law remains the same. It's a particular solution. But we say the consequence of Section 9 being a personal jurisdiction provision concerning forum convenience, it means it has the same legal and evidential burdens of proof as a common law. The interlocutory default judgment standards of proof are the same. And the mechanism of proof for proving foreign law, which is to say, if it cannot be agreed, then it needs to be resolved by expert evidence, is the same. That's our very straightforward case on what Section 9 does. My learned friend's case is that Section 9 and 10 are radical new subject matter jurisdiction exclusions, which therefore can be raised at any time. Possibly even on appeal, but certainly as late as at trial. They could be raised at any time, and even if raised, apparently we heard this morning, could be re-raised. There wouldn't be an issue of stop, but if new facts came to light, it could be re-raised by a party. They would oust the jurisdiction of the High Court to hear a certain class of libel claims, which it could otherwise hear, even if both the parties wanted the High Court to hear it. So if there was a libel tourist suing a very willing libel kidnappee, it would not be possible for them to waive the objection and have the case heard by English judges that both regarded as fair. The English court could not hear it. We struggle with that submission for a number of reasons, which I'll come on to. Firstly, if it is an ousted clause, it's far from clear. In fact, until Mr. Justice Julian Knowles in Sadek and Sadek, I don't think anyone had suggested that it worked in that way. Mr. Justice Nicklin, in Wright and Barrett first instance, certainly didn't agree that it worked in that way. It's very difficult to think of such an ouster, certainly in private law. We've tried to give some examples of those sorts of subject matter jurisdiction exclusions. So no judicial review of the Crown Court when acting on its in its capacity trying an indictment. But even fairly clear ouster clauses, such as no judicial review of the Investigatory Powers Tribunal, have struggled before the courts. This certainly isn't clear. We say as a matter of policy, very difficult to see why Parliament would have chosen subject matter jurisdiction rather than personal jurisdiction. It's aped the language of forum non conveniens, it's aped the language of the test in 637, clearly most appropriate. And there's no particular policy reason. One can imagine, for instance, exclusions like diplomatic immunity. Diplomatic immunity is incredibly important. There's a high policy reason behind having it. That can be waived. It's fundamentally a matter of personal jurisdiction, not subject matter. And nor is it clear why the subject matter jurisdiction would not be a clean and definable class of cases, but it hinges in section 9 on an evaluative assessment of appropriateness, which is a slightly fuzzy-edged definition of something's important as subject matter jurisdiction. And in section 10, the practicality of suing persons who are not parties before the court. We say that that's absolutely no basis for something as remarkable as an ouster of the High Court's general jurisdiction, certainly its jurisdiction until libel claims. Now, the consequence of these two different visions of what sections 9 and 10 are doing is that if we are right, section 9 modifies forum conveniens and fundamentally concerns personal jurisdiction, I don't understand there to be any dispute. There's no reason to think that the evidential burdens, standards of proof, or mechanisms of proof are any different whatsoever. And so it would be dispositive. But even if my learned friend was right that sections 9 and 10 concern subject matter jurisdiction, there are very good policy reasons articulated particularly by Mr. Justice Hamlin, as he then was in Albemarle, and looking at the run of cases back to Mr. Justice Ricks in Concola Mines. There are good policy reasons articulated by Lord Sumption in Brownlee, looking back to the House of Lords in Vicovicci. There are reasons that interlocutory challenges use good arguable case rather than the balance of probabilities. And there are good policy reasons why, even where legal burdens fall squarely on claimants, there might nonetheless be evidential burdens on defendants. And the submission that I will be making in the fullness of time is that even if my learned friend was right, sections 9 and 10 concern subject matter jurisdiction, those policy reasons, I was about to say, would apply with equal force to libel claims as they do in any other claim. Actually, they apply with far more force in online libel claims, at least, than they do in almost any other case. And the simple reason is this. If you have a case like Brownlee, which is a very serious, indeed fatal accident abroad, there's very little doubt about the jurisdictions that are in play. Both parties know it's where the accident took place, where the claimant has then suffered its consequential loss. There's no particular information asymmetry as to the available courts that there might be. And the parties are relatively able to predict that and to draw the attention of the court with expert evidence if necessary as to whether a foreign forum that they prefer is available and appropriate. If one considers an online libel claim, it might be against the New York Times, in which case there's public information that says they sell 1 million copies in New York and have 3 million subscribers, most of whom are in the US. And that might be quite straightforward. But in this case, where you're suing multiple defendants who live in different states, it's a relatively new outlet. It doesn't have public information about where things have been published. The defendant has that information, and the claimant doesn't. What's more, the claimant can't possibly anticipate where publication will necessarily have been greatest, and can't possibly be expected, if expert evidence is required on the availability of a foreign forum, to adduce expert evidence on every possible forum that the defendant might say is not more appropriate, but sufficiently appropriate to defeat his Section 9 claim. There would be very good policy reasons, even if Section 9 concerns subject matter jurisdiction, to follow the approach articulated by Mr. Justice Hamlin in Albemarle, but endorsed in Livingston by the British Council, by the Supreme Court in Unwired, to say the claimant has set out his case on why this jurisdiction is the most appropriate and puts it before the court the information that he has available to him as to why that's so. Now, in a service out case, he can only so over English publication, and he'll give the factors if he's domiciled here, if all of his family is here, if his businesses are here. That might be relatively straightforward. But we accept that the legal burden always remains on the claimant in Section 9. but there is nothing offensive and there is very good sense behind the reasons for saying that it's for the defendant, who, even the merest blogger, does have the information about the geographical distribution publication, to say, these are the places where there was significant publication, and or for other reasons, I think it would be more appropriate for you to sue me. They don't have to do much more than identify that jurisdiction and show, either by agreement or expert evidence, that it's available to hear the case. And as soon as they do that, the burden then, clearly, the legal burden falls on the claimant to show why England and Wales is clearly more appropriate. But that step is necessary, whether this court finds that it's personal jurisdiction or subject matter jurisdiction. So the end of my introduction, if you like, is even if my learned friend was right about subject matter jurisdiction, it still follows that the burdens, standards and mechanism of proof are as we say they are. So our headline submission is that there are 4 major issues, questions with binary answers, for this court to resolve on Section 9. The first is the type of jurisdiction. Is it personal or subject matter? The second is the burdens of proof. The legal burden falls on the claimant, but evidential burdens on the defendant? Or is it, as my learned friend says, that all burdens, legal and evidential, just fall on the claimant? The third major issue is the standard of proof. Is it the good arguable case as it is for all other interlocutory applications or jurisdiction? Or is it uniquely the balance of probabilities, my learned friend suggests? And fourthly, though this is not actually in dispute, or at least it wasn't disputed below, that the judgment of 149 records the concession that judicial notice could not be taken in foreign law. If there is no agreement, is expert evidence on foreign law required on availability and appropriateness of another forum? We say yes. I'm not actually sure that is in dispute, but obviously the hypothetical other answer would be no. The type of jurisdiction, burden of proof, standard of proof, mechanism of proof. They are the 4 issues. We also say that Section 9, you need to consider, as it were, the 3 stages. So the first question is the jurisdiction provision, and this is probably as true of Section 9 as it is of Section 10. Is the jurisdiction provision in question engaged? We know from Section 9.1 that Section 9 is only engaged if a person is domiciled outside of now the United Kingdom. At the time it was outside of the Brussels-Lugano territory. But there's a question of fact as to whether or not Section 9 is engaged at all. Somebody has the burden on that. There is a standard of proof that applies to that. Now, in all other jurisdiction applications, the question of domicile, the burden would be on the claimant, the legal burden would be on the claimant, to assert that the person was domiciled where they said the person was domiciled. So Cherney and Deripaska we've included. It was for the claimant to prove a good arguable case that the defendant was domiciled in the United Kingdom if he was to be sued under what was then Article 2 of the Brussels I regulation. But obviously if he asserts it, there would then be an evidential burden on the defendant to rebut it, and then the legal burden reverts back to the claimant. It's the same as any other issue. So the first question is this jurisdiction provision engaged? The second question is, if so, is there another candidate forum that is available? We get that question from Unwired, we get it from Albemarle. And the third question is, if there is another candidate forum available, which available forum is more appropriate? And as I get to the end of my submissions, I'll be explaining, if you like, the 4 major issues through the prism of those 3 questions as it relates to Section 9. Forgive me, my lady, I can't quite see the clock because of the lights.
It's, I'll let you know when we're nearing 1 o'clock. It's about
12 minutes.
12 minutes to.
Very great. So the structure of my submissions is going to be as follows. I'm going to deal with ground 1 of the appeal and both grounds of the respondent's notice compendiously on those issues of law as I've discussed. First, by doing a review of the common law position, which I will take quite quickly because I think I have set it out quite fully in my skeleton argument. Secondly, looking at Section 9 of the Act and construing it harmoniously with Section 10 in light of the prior common law position. And then thirdly, I want to turn to these 4 major issues in the 3 stages and the way that we say it works. My ladies, my lord, starting then with the common law position. If I am taking this either too quickly or too slowly, please do let me know. The relevant beginnings of this is at paragraphs 19 to 22 of our skeleton argument. And we say that from Lord Sumption's judgment in the case of Le Chaux, in particular at paragraphs 1, but also 11 to 13 of that decision, we say that there are principles of construction that will guide the court in answering questions about Section 9 and indeed Section 10 of this appeal. The first is that the 2013 Act is an act to amend the law of defamation. Parliament is presumed to know the state of the common law when it legislates. In particular, the 2013 Act followed previous attempts in 1952 and 1996 to, in its own title, to amend the law of defamation, not to codify necessarily or transform it ab initio. And it's for that reason that Lord Sumption, in paragraphs 11 to 13, explains that a maxim that should guide courts as they construe the provisions of this not quite so new Act, now 8 years later, is from Black Lawson that Parliament should not be presumed to have amended the common law more than was necessary. And that quotes paragraph 21 of my skeleton argument. And that submission met with the favour of both parties and indeed the court in the first appeal on Section 9 of the Act, which was right and fair in this court. And for your ladyship's and your lordship's note, that's paragraph 51 of the Court of Appeal in right and fair, adopted that as a principle. Skipping a little ahead, we've pointed out in the skeleton argument, I'm not going to do this in any detail, this case is about Section 9 as it was originally enacted. There's obviously been quite a dramatic change as of the new year, in that the Brussels-Lugano Convention no longer part of our law, except that this case, and many others, has been saved by the transitional provisions. And so whereas once upon a time Section 9 applied to defendants outside of the Brussels-Lugano territory, now it applies to all defendants who are domiciled outside of the United Kingdom. The other change that the law makes is that because of Brexit, the Brussels regulation no longer has direct effect. And that maybe makes a small change at the margins of this case, just based on a submission that was made to you this morning by my learned friend, which is that while the Brussels regulation applied, and it's saved as it applies to this case, it had direct effect. And Article 6, we've put this in our skeleton argument, Article 6 governed bringing proceedings against defendants who lived outside of the Brussels-Lugano territory, who were not in another member state. And it provided that for such claims, national law would apply. But that national law would apply with the proviso that any person, irrespective of his national origin, could rely on the rules in force. And general principles of EU law would mean that you couldn't have a system where national law applicable through Article 6 of Brussels discriminated on the basis of national origin. Now, I flagged that point only in response to what my learned friend was saying, which was saying that notwithstanding that Mr. Justice Jay had rejected as a fact that my client had a sort of a global reputation, that he was one of these sort of global figures, and that's paragraphs 140 to 142. There was a sense this morning that my learned friend was seeking to distinguish between sort of English people who had always lived here and never left, as opposed to someone who perhaps was born abroad and had come here and been naturalised as an adult, and whilst domiciled here, we would say has centre of interest here, might be treated an awful lot differently because, you know, he would inevitably have some degree of reputation abroad, and that therefore felt to be treated differently. I would just say, if that was the case being put, we say that wouldn't be permissible. Section 9 here, and indeed all domestic law in this claim, is being applied through the prism of Article 6 of the Brussels Recast Regulation. And it doesn't permit for the sort of different fetters on people based really purely on their national origin. So if my client's centre of interest truly is here, he is in no different position to anyone else who has, in the true sense, their centre of interest here. I just want to put that down as a very brief marker. Otherwise, the Brussels regulation really doesn't have any particular role to play. This falls to be treated as a matter of purely domestic law, which means service out, CPR 11 applications, and indeed the common law doctrine of forum conveniens. And I don't understand there to be any dispute as between the parties as to how forum conveniens, whether it's a service out or service as of right and application for a stay, whatever the mechanism, forum conveniens and its burdens and standards of proof is fairly well understood at common law. And it was common law that applied, of course, to all of the other causes of action in the application before Mr. Justice J. At common law, if it's service out, claimant bears the legal burden of proof and has to show that England and Wales is clearly the most appropriate place for the trial of the action. In the other situation, service as of right, which can still be against a foreign domiciled defendant. It could be the foreign bureau of the New York Times, or it could be a foreigner who's passing through Heathrow, or there are a number of other foreign defendants who could be served as of right, even after Brussels Vagina has gone away. But if there's service as of right, at common law, the burden of proof, the legal burden, actually falls on the defendant to displace it, and that defendant has to show that the foreign forum is clearly more appropriate for the trial of the action. So one of the big impacts that everybody except Section 9 has had on the common law is that it's harmonised the burden of proof. It always now falls on claimants, irrespective of mode of service. The legal burden falls on claimants. And secondly, that the claimant always has to show that England and Wales is clearly more appropriate. There's never a circumstance where you have to show that a foreign court is clearly more appropriate. And those two changes to the common law, I think, are accepted. One thing that is tolerably clear in the common law, but it becomes an awful lot clearer through analysis of the Brussels regulation, and we say was in fact accepted by the Court of Appeal in right and there, albeit that the parties agreed on this, is that when the comparison is to be struck, when we are talking about another place, the word place in Section 9 means the same as place in the Brussels recast regulation, and indeed place at common law. A place is another jurisdiction. It's a place that has its own courts, its own law. So certainly we would say that would be the three jurisdictions of the United Kingdom. We say it would be the states of states and commonwealths of the United States, the states and commonwealths of territories of Australia. It might also encompass federal systems if that jurisdiction has its own law and its own courts that operate differently. But the comparison is between places. And we say Mr. Justice Dingemans at 61 of Right and Bear accepted that. If there is any doubt, I have included in my skeleton argument at paragraphs 32 to 34 the relevant articles of the Brussels recast regulation. Section 9 obviously has Brussels recast in mind because Section 9.1 in its original enactment was predicated on whether or not a party was within or not within the Brussels recast regulation. And the way the Brussels recast regulation, and indeed the domestic law, the Civil Jurisdiction and Judgments Act, which gave effect to the Lugano Convention, the Brussels Convention, the discussion is always about the courts for the place. So we're familiar from cases like Shevell about courts for the place where the harmful act occurred and what that means. And you can see, taking an example, Article 11 talks about the distinction between the courts for the member state and the courts for the place, and it uses them quite differently. And there's a particular article, 43 2b of Brussels, about translation, which makes very, very clear beyond peradventure, that when the Brussels regime at least talks about a place, it's talking about a sub-member state area that has its own courts and jurisdiction. What we know from Right and Bear was a slightly unusual appeal in that ultimately the appeal was dismissed, but it was dismissed on the basis that the Court of Appeal agreed with the judge below on the facts because of the respondent's notice put in. But the second ground of appeal in Right and Bear, and I will come to it, was that Mr. Justice Nicklin had erred in law by not conducting a comparison between two places. And as we'll come on to see, the Court of Appeal accepted that he hadn't done that, and therefore they needed to make the decision at first instance again and found against the appellant. But at the heart of Section 9, the one thing that should be taken from Right and Bear is that Section 9 mandates a comparison between two fora, which are places of publication, but they have to be places that are available to hear the action, because if they're not available, then they can't possibly be more appropriate. How this works at common law is a slightly larger topic. I wonder I might hold over until
I think we've covered quite a lot of ground at speed. So we'll rise now and sit again at 2 o'clock.
Stand, please.